Hey guys, we're back and gonna review chapter 5 from unit 2. Go ahead and pull the PowerPoint up. So we're going to discuss legal and legislative issues. Um, this is where some people kind of don't think about nursing and medical and how much the legality, law, and legislation that happens at the state level and the national level um, overlap what happens in healthcare. A good example that's going on right now in the news, I'm sure everybody's heard about it, whether depending on how you fall on either side doesn't matter, but just understanding that the state of New York recently changed their laws on abortion and saying that you could abort to later in pregnancy if there's something wrong with the baby or a health problem with the mother. But this is obviously something that is a medical issue that the law has come into place, and they do overlap a lot. And sometimes then ethical decisions can come into play with this too, such as that situation. But it's kind of a good example about how the legal, ethical, or many legal and ethical parts of health. So the purpose of law and legislation is to protect the patient and the nurse, the primary purpose. Laws and legislations define the scope of acceptable practice and protect individual rights. Nurses who are aware of their rights and duties in legal matters are better able to protect themselves against liability or loss of professional licensure. It's really important that we're going to get into it more to understand the Nurse Practice Act and the laws and what you're covered by and what you're not. So, source of laws. There's origin of the law, the Constitution, statutes, administrative agencies, and court decisions, and then the use and the impact on nursing practice. So the Constitution is the highest law in the United States, interpreted by the U.S. Supreme Court. It gives authority to the other three sources of the law. And the impact on nursing is there's little direct involvement in this area of malpractice. So statutes, also called statutory law or legislative law, that are passed by the state or federal legislators and that must be signed by the president or the governor. Before 1970, very few states or federal laws dealt with malpractice. Since the malpractice crisis, many statutes affect malpractice. Administrative agencies. These are the rules and regulations established by appointed agencies of executive branch of the government, governor or president, and some of these agencies, such as the National Labor Regulations Board, Relations Board, and the Health and Safety Boards, can affect nursing practice. And there's court decisions, also called tort law. And this is a court mode law, and the courts interpret the statutes and set precedents. In the United States, there are two levels of court: trial court and appellate court. Most malpractice laws are addressed by these courts. So let's go for our first question. Tell whether the following statement is true or false. Nurse practice acts are examples of statutes. True or false? That's true. The 51 nurse practice acts representing the 50 states in the District of Columbia are examples of statutes. These nurse practice acts define and limit the practice of nursing, thereby stating what constitutes authorized practice as well as what exceeds the scope of authority. Sorry, there was a siren and now types of laws and courts. There are three different types. There's criminal law, civil law, and administrative law. So in criminal law, for the burden of proof required for guilty verdict, there needs to be beyond a reasonable doubt, and likely consequence of a guilty verdict is incarceration, probation, or fines. I think we all kind of know that side of things. For civil, it's based on a preponderance of the evidence, and it's usually monetary damages. So that's when, like, you think of like people suing each other and that kind of thing. And then administrative law, there are clear and convincing standards, and it's usually a suspension or a loss of licensure. So this is like going to court and your license being taken, possibly being taken away. And the State of Florida Board of Nursing does does carry on legal aspects like this, where they would do the administrative law and could potentially suspend or lose your license. And sometimes that can be based on criminal things, or usually not civil disputes, but criminal things, such as if somebody gets a DUI and is convicted of a DUI, they could lose their license possibly. So a nurse is charged with administering a fatal dose of morphine to a patient on hospice. In which type of court would this nurse be charged? Civil, criminal, administrative, or none of the above? It would be criminal. And the reason for that is the nurse is found guilty of intentionally administering fatal doses of drugs to patients would be charged in a criminal court. In civil cases, one individual sues another for money to compensate for a perceived loss. In administrative cases, an individual is sued by a state or federal government agency assigned the responsibility of implementing governmental programs. So legal doctrines regarding guiding courts in decision making. There's the satire decisis. It's let the decision standard. It uses precedents as a decision making guide. The res judica. It's a thing or matter of settled by judgment. And that applies only when a competent court has decided a legal dispute and when no further appeals are possible. And then respontent superior, and that's the master is responsible for the acts of his servants. That's what it stands for. And that's where an employer should be held legally liable for the conduct of employees whose actions he or she has the right to direct or control. So there are two types of negligence. This is ordinary negligence and professional negligence, also called malpractice. And nurses are at an increased legal liability in the 21st century, owing to the following. They must have moral authority and independence in decision making. They have increased legal accountability for decision making. They are performing more actions that used to be in the realm of medical malpractice, and they are making more money. More nurses are carrying malpractice insurance. So most hospitals carry malpractice insurance for you, and you're typically covered under that, depending on what kind of nursing you go into. And then even if you go and become an advanced practice nurse, you will have to carry malpractice insurance. So which of the following accurately describes why nurses are at an increased liability for malpractice suits? Their realm of responsibility has decreased. Fewer nurses have liability insurance. Nurses are making more money. Nurses currently have less independence in decision making. C, nurses are making more money. Higher salaries have corresponded to an increase in liability in the nursing profession. The malpractice insurance dilemma. Nurses need malpractice insurance because of their expanded roles, but they also incur a greater likelihood of being sued if they have malpractice insurance, because injured parties will always seek damages from as many individuals as with financial resources as possible. So this is kind of the dilemma where a lot of hospitals, and wherever you decide to practice and you actually become a nurse, they typically in orientation will go over this with you. But a lot, like where I work, they don't recommend if you're a registered nurse to go get your own malpractice insurance. It is covered. The hospital does have insurance, and that way, if you have malpractice insurance, someone's more likely to come after you, where they would just go after the hospital initially. So elements of malpractice: negligence, the omission to do something that a responsible person guided by the considerations that ordinarily regulate human affairs would do, or as doing something that a reasonable and prudent person would not do. And then malpractice is the failure of a person with professional training to act in a reasonable and prudent manner, also called professional negligence. So the malpractice comes in when it's the negligence within your profession. So 5 components necessary for professional negligence to occur is the standard of care in practice, minimal level of expertise delivered to a patient. There is a failure to meet the standard of care, breach of duty. So, we think about like evidence-based practice. There's a standard of care for each patient. You have protocols, policies to follow. There's physician's orders that you're following. That's your standard of care, that if you fail to meet that basic standard, you don't follow out an order or follow out an order incorrectly, that's negligence and that could be malpractice. Foreseeably, the harm must exist. Ignorance is not an excuse. You can't say, well, I just didn't know it was okay to not give that medication. This is why they really, really harp in a nursing school with you that if you don't understand something or have a question or concern about an action you're taking with your patient or a medication you're giving, you should ask and do research and look to see what that is, because just saying, well, I didn't know isn't good. We're dealing with people's lives. There must be able to provable correction between care and harm, provable correction between care and harm, and actual patient injury must occur. And this is why a lot of times hospitals like you to still, because we say we do instant reports and things when stuff happens to patients. Even when they're like near misses, like something like a medication accidentally got given that wouldn't have been appropriate, that was like an allergy to the patient, but it was ordered, it went through pharmacy, it shows up at you're doing your double check, and you're like talking to the patient, looking at their allergies, and you're like, wait a minute, they have an allergy, they have an anaphylactic reaction to this medication, but it went through all these pieces, got to you, and you're the last step between that medication and the patient. If you were to still give it to them, that would be negligence, because did you follow out with checking on if they had that allergy? Well, say it got to you, you caught it, you said, no, this patient has an allergy to this medication, I'm not going to give it, I'm going to do follow up, talk to the physician, talk to the pharmacist, make sure they're all aware of that there's an allergy listed, that it's like an anaphylactic reaction, like, we're not doing any pre-medications for this, just doing those questions, that using your critical thinking skills to work through. Sometimes hospitals still want you to make sure to do an incident report or something so that they know that event happened because there was a break in the system. It made it to you and you caught it, but why was there that many breaks in the system? Why did the physician not catch there was an allergy? Why did pharmacy not catch there was an allergy? Those kind of things, and it's good for us to be aware of it. It's not placing blame on somebody, but it's looking at breaks in the system to make sure it doesn't happen to somebody else, and that maybe there would be another nurse that would get it and didn't catch it on their administration of medication and could potentially kill somebody. So that's why it's good to be aware of when those near misses happen to help prevent negligence and malpractice in the future. So being sued for malpractice, just following physician's orders is not a defense for malpractice. So great example, like if you're giving a medication and the patient has an allergy, it's a listed allergy in the chart. You did your double check, talk to the patient, they have an allergy, yes. You can't say, well, the doctor ordered it, so I gave it. No, you can't. That's not an okay. You would still need to follow up and say, and like talk to the physician. You realize there's an allergy for this, and make sure those steps have been in place to show that you acknowledge that you saw there was an issue here and followed up with it. Nurses have an independent responsibility to take appropriate steps to safeguard patients. So exactly what we've been talking about. So question, tell whether the following statement is true or false. Following a physician's order is a valid excuse in a malpractice case. True or false? Be false. Nurses have a responsibility to safeguard their patients independent of physician's orders. So if you ever have a question about a physician's order, think it doesn't make sense, it doesn't sound right, you completely have the right and should follow up with it. Reducing the risk of malpractice claims. Practice within the scope of the Nurse Practice Act. Observe agency policies and procedures. Model practice after established standards by using evidence-based practice. Always put patients' rights and welfares first. Be aware of relevant law and legal doctrines, and practice within the area of individual competence and upgrade technical skills constantly. So be constantly trying to increase your knowledge, understand the patient population you're working with, understand the best practices for that patient population. So independent reports, adverse event forms, incident reports, so like what we talked about earlier. These are records of unusual or unexpected incidents that occur in the course of a client's treatment. They are generally considered confidential communications and cannot be subpoenaed by clients or used as evidence in their lawsuit for most states. A copy of an incident report should not be left in the chart, and no entry should be made in the patient's record about the instance of his incident report. So every organization, whatever organization you end up working for when you're practicing as a nurse, will have some kind of incident form manager that system that you would report to when there were incidences. You don't ever write a nurse's note saying, oh, put an incident report in this date or time. You don't usually write notes in regard to the incident that happened unless it's like necessary to write that you called a physician. So in the previous case we talked about that you could definitely write a note saying that you did communication, that you paged the physician to verify medication ordered. You wouldn't write, I called the physician to check if he meant to order the medication because patient has an allergy to it. You never want to call somebody out or say that somebody else did something wrong in your documentation, because the patient record can always be subpoenaed to court. What you write in the incident report is confidential. That's another reason why we don't say that you did the incident report, because if you did, then they could possibly try to subpoena it as well. And the incident report's not supposed to be punitive. It's supposed to be used as a resource to see what happened in that case, and also can be used for future to help educate so something like it doesn't happen again. So intentional torts are assault and battery, false imprisonment, invasion of privacy, defamation of character, which is slander, which is spoken, defamation of character, and libel, which is the written form. So which is not an intentional tort? False imprisonment, defamation of character, invasion of privacy, or negligence? The answer is negligence. An intentional tort requires that the act be committed with the awareness of a proprietor. Responsibilities of the nurse manager are reporting dangerous understaffing, checking staff credentials and qualifications, and carrying out appropriate discipline. So guidelines for informed consent. This is the person giving consent must fully comprehend. So we want to make sure that the person is competent and able to understand the information being given to them. If they're not, then we need to question if they have the capacity to make their own decisions, and does a proxy need to be set up, or do they have somebody as a medical proxy already, or someone to make their own decisions. The procedure, we need to make sure when we're giving informed consent, or when a physician is giving conformed consent, that the person understands the procedure to be performed, the risk involved, the expected or desired outcomes, the expected complications or side effects that may occur as a result of treatment, and the alternative treatments that are available. So you sometimes will hear nurses say it's not their job to get informed consent, and it is the job of the physician to make sure that the patient that they're going to be performing a procedure or surgery on fully understands it. Absolutely, the physician is the one that needs to go over the procedure, the risks involved, all of these things. But the nurse is also there to make sure that the patient or the person making the decision can comprehend and understand it all, and can ask questions and then also relay those to the physician. So they're kind of that advocate middle person in this situation. So consent may be given by a competent adult, a legal guardian, or individual holding durable power of attorney. So this is maybe the person is either underage, or they are have been deemed not able to make them not to be competent. They can't make their own decisions. They lack capacity. So you hear that used a lot. That somebody lacks capacity. Then if they have already set up an individual holding durable power of attorney, that person would make decisions for them. Or a proxy would be appointed while the person is in the hospital. That proxy is only valid while the person is in the hospital. An emancipated or married minor, a mature minor, that varies by state. In the state of Florida, mature minor is not considered somebody that can make decisions for themselves, 18 or over, unless they were emancipated. Parent of a minor child, or somebody that has a court order. So there are people that come in and are no longer, they lack capacity, can't make decisions for themselves, but yet have no family. They aren't able to make, they don't have children, adult children. They have, their parents maybe have passed. They have no siblings. They didn't really have any close relatives or close friends. These are people that the court will appoint legal guardians for. And this is somebody that they're just people that that's what they do, is they are legal guardians for those that can't make their own decisions. And that is a timely process to have to get in place. But we can't, but their social workers will work and get that done to where they have court-appointed guardians. Patient medical records. The patient owns the information, but the record belongs to the facility that made it and is storing it. Patients must have reasonable access to the records. They can always come and request it. And we say reasonable doesn't mean right in that second. They're going to get a printout, but within a reasonable amount of time, they can go to a hospital, request their records, and they may say, okay, can return it now, and we'll have the records printed and available for you. Collaboration between healthcare providers and patients and documentation thereof is a good indication of a well provided clinical care. Many facilities are going towards online. Obviously, we have online medical records, but even for patients, having online patient portals so that they can access their medical records readily at any time. They can go on and see what their lab results are, those kind of the results for different procedures or different scans that are done, and that way they at any time can access their medical record, which is nice. It takes out that middleman of having to go medical records area and get things printed or scanned off for them. So Patient Self-Determination Act, or PSDA, is a requirement healthcare organizations that received federal funding, which would be Medicare and Medicaid. Every single healthcare organization receives Medicare and Medicaid funds, to provide education for staff and patients on issues concerning treatment and end-of-life issues. This includes the use of advanced directives, written instructions regarding desired end-of-life care. Also likely includes durable power of attorney for healthcare. So as many of you, because you're in your senior year, you've been in the hospital. If you're like been at Lakeland Regional and started to help with a admission of a new patient, one of the questions that is asked for every patient admitted to the hospital is, do you have an advance directive or living will? If they say yes, we say, is it on file? If not, can you please bring a copy of that in? If they do not have one, they are asked, would you like help filling one out? And we encourage them to fill one out. Somebody from pastoral services will actually come down and sit with them. And it's kind of a pre-printed form, very easy to use, checking boxes. And also on the back, they identify who they would want to be their healthcare proxy or their durable power of attorney if they were to need that. So it's kind of a way of having that on record for us. It goes home with them. But that when the patient comes back in, if they are in a situation where they're compromised, we know what their decisions were, we know what they wanted, and we're able to follow those wishes. And it makes it easier for the family because there's not a question of, I don't know what they wanted. I don't know if they would have wanted to have a trach placed. I don't know if they would have wanted long-term be on a ventilator. Those questions are asked in that. So that's why it's really important, and that's and with this Patient Self-Determination Act, it has been put in place to make sure all facilities ask these questions. So Good Samaritan laws, some of you may have heard that with Good Samaritan laws, nurses could stop if they see a car crash, something like that on the side. But what they do is they suggest that healthcare providers are typically protected from potential liability if they volunteer their nursing skills away from the workplace. So like generally, it's limited to just emergency situations. And provided that the actions they taken are not grossly negligent, and if the healthcare worker does not exceed his or her training or scope of practice in performing the emergency services. For example, I've had a couple instances since I've been a nurse happened where the most recent was actually, I was up by Florida Southern going to an event, and I live very close to campus, was walking up and saw a biker get hit by a car. I ran over. She was okay. The biker was okay, but I stayed with her, helped her, just kept her calm, had her sit on the side, kind of looked at her leg because she was a little banged up, called the police for her. but didn't mean that was it, just stayed with her to make sure she was okay. I previously had an incident where a car, like a biker, like a motorcyclist, was hit, and he was more severe. There was blood on the ground. The only thing I did there was I showed up, and people were wanting to take his helmet off, and I said, no, we need, I'm a nurse, we need to make sure we keep his, just keep him where he is. 911's been called, keep his helmet on, kind of kept him in C-collar, make sure that his head was not turning in case there was some kind of spinal cord injury. And that was all I did, because that's my scope. That's what I know. I am not an emergency medical person. If somebody fell out and was needing CPR, yes, I could do that, but you're never wanting to do anything more than what you know, or something that, we are taught, in trauma situations, you would never take the person's helmet off. You would never turn them or move them from from where they're at in a trauma situation. So if I was to rip his helmet off, be turning him all about, that could then be negligence, because obviously that was outside my scope. That's not appropriate for you to do with a trauma patient. So Health Insurance Portability and Accountability Act of 1996. This provides patient rights to confidentiality, essentially that represents two areas of implementation: administrative simplification plan and privacy rules. This is HIPAA. Everybody's heard of HIPAA. We can't go around telling information about our patients. That's all confidential. If you're saying things like the only people that need to know information are those that are taking care of that patient. If you are in the hospital and see somebody that you don't really walk up to them and say like, "Hey, what's going on?" If they're your patient, then you can ask these questions. But if they're not your patient, it's just the person in the room down the hall, you can't start going like, "Hey, what's going on with them? What's happening?" It's kind of on a need to know basis. And then common causes of professional nursing licensure suspension or revocation. So getting your license taken away or getting it suspended, which none of us ever want. Professional negligence, practicing medicine or nursing without a license, obtaining a nursing license by fraud or allowing others to use your license, felony convictions of any offensive sustainably related to functions of or duties of an RN. This is where a lot of people, drugs and alcohol and those kind of things cause. Participating professionally in criminal abortions, not reporting substandard medical or nursing care, and providing patient care while under the influence of drugs or alcohol. That will get your license taken away. Something that actually came up recently in the news that I think because you guys are students, you should know. At least there are several states, state of Florida is one of them. If you go behind and default on your student loans, they can actually take away your license based on that. If you have federal student loans that you default on, that is something that your license can be revoked for. So do not fall behind on your student loans. And that actually, I think recently there was an article I saw on Channel 8 News. It was an article, so it was a news show about it, saying that the state of Florida, I believe it was 10,000 people, got their license revoked because of defaulting on student loans. Giving narcotic drugs without an order, that would obviously be a reason for suspension. Falsely holding oneself out to the public or to any healthcare practitioner as a nurse practitioner. You cannot say you are a nurse practitioner unless you are an advanced practice nurse that holds the license of advanced practice registered nurse. I can't say I'm a nurse practitioner. I'm a clinical nurse specialist. I can say I'm an advanced practice nurse because I am, but I'm not a nurse practitioner. So registered nurses can't just say they're nurse practitioners. And that is it. I'll see you guys in chapter 6.